Hello guys, welcome back to another video. So friends, today in this video we will discuss with you about the administrative tribunals and with special reference to the Central Administrative Tribunal as to how it is established, what are the functions of CAT and what are the procedure of administrative authorities and the judicial powers of the members of the administrative tribunal and what are the characteristics of it. So firstly we see how it is established. So basically the administrative tribunals which are to be established under the Administrative Tribunals Act 1985 may be classified into three categories. That is the Central Administrative Tribunal, second is State Administrative Tribunal and the third is Joint Administrative Tribunal. All three kind of administrative tribunals are to be constituted by the central government by a notification. Each of the administrative tribunals is to consist of a chairman, a number of vice chairmen, judicial members and administrative members. The chairman, vice chairman and other judicial members as well as administrative members are to be appointed by the President of India. The CAT deals with the matters related to central government employees such as railways, postal, telecom, insurance, etc. that is work for the central government. That means the case of before the tribunals are maintainable by the central government employees. Now we see what are the powers and functions of the Central Administrative Tribunal. The Central Administrative Tribunal is to take cognizance of service matters relating to all India service or to any civil services or civil post under the center or to a post connected with defense or a defense service to which a civilian is appointed. Besides this, service matters in any authority, corporation or socially owned and controlled by the government of India can also be placed under the jurisdiction of the tribunal. A chairman who has been a sitting or retired judge of a high court heads the Central Administrative Tribunal, and besides the chairman, the authorized strength consists of 16 vice chairmen and 49 members. The conditions of service of chairman, vice chairman and members are governed by the provisions of Central Administrative Tribunal. Salaries and allowances and conditions of service of chairman, vice chairman and members rule 1985 as amended from time to time. Now what is the procedure of administrative tribunals? On receipt of the applications, if after investigation the tribunal is satisfied that the application is fit for adjudication or consideration, it will accept the application. However, if the tribunal is not so satisfied, it will reject the application after recording the reasons. The tribunal is not bound to follow the procedure prescribed by the Code of Civil Procedure 1908 while functioning under the provisions of Administrative Tribunals Act and the rules framed by the central government. It has the power to regulate its own procedure, and the procedural rule cannot be contrary to the natural justice. The tribunal has all the powers of a civil court in respect of calling a person, administering oath, compelling discovery and production of documents, issuing commissions, reviewing its decisions, etc. As regards contempt, the tribunal has the same jurisdiction as has the High Court. It can exercise its powers in this respect as the High Court exercises. Now, what are the judicial powers of administrative tribunals? The doctrine of judicial review is a part of the basic structure of the Constitution, and as such, it cannot be excluded even by the constitutional amendment. The validity of the Administrative Tribunals Act was challenged on the ground that it seeks to exclude the doctrine of judicial review. Section 28 of the said Act has excluded the power of judicial review exercised by the High Courts in service matters under Article 226 and 227 of the Constitution. However, it has not excluded the judicial review entirely in such a matter as the jurisdiction of Supreme Court of India under Article 227 of and Article 136 has been intact. So, what is the structure of administrative tribunal? And tribunal is the creation of statute, and thus it has a statutory origin, and in some cases they may be established by the executive under the delegated legislation. So now what are the characteristics of these tribunals? The characteristics of these tribunals are: the proceedings before it must commence on an application which is in the nature of a plaint in the form of a suit. That is to say, an affidavit is to be filed, and this must be in some proper format after attesting the affidavit on oath, and it has the same powers as regards the discovery, inspection, taking evidence as are possessed by a civil court. However, the CPC will not be applicable for it. Witnesses are examined and cross-examined in a court of law. The tribunal be represented by a legal practitioner. Members of the tribunal are persons qualified to be the judges. It's the same. Tribunals are established by the executive under the provisions of the statutes. Although they are required to act judicially, they perform quasi-judicial functions, and the tribunals are independent and impartial and work without being influenced by the government. And they have the power of the civil courts in certain matters, and their proceedings are considered to be the judicial proceedings. And the tribunals are required to follow the principles of natural justice in deciding the case that we have been discussed in the playlist of administrative law, that as to what are the principles of natural justice: rule against bias or de altrum portum, and there must be a reasoned order or speaking decision. So friends, I hope you like this video on the topic of central administrative tribunals, as to how it is established, its procedure, its functions, its characteristics. Thanks for watching this topic, and see you with the help of new video. Thanks for watching the video.